Thank you so much. It's really a great pleasure to be here, and I want to thank you for the invitation. Like I said, I'm honored to be sharing some ideas with you and talking about how we can provide perhaps greater legal protections for non-human animals who, as sentient beings, deserve good welfare and an appropriate habitat. Today, I'm going to be presenting on efforts to provide protections for animals at the international level by setting minimum global standards for their treatment via an international convention on animal protection for public health, animal welfare, and the environment, or CAP for short. I'm first going to explain why an international convention is needed, and then recount briefly prior efforts at addressing animal welfare at the global level. Next, I'll discuss how the recent pandemic is an opportunity for advocates to gain headway in this area and persuade nations to negotiate such a convention based on the One Health approach. And I'll then end with a brief discussion of CAP. It's the latest draft that we're working on to propose for a convention on animal protection. Slide number 2, please. An international convention to protect animal well-being is needed. First, at the national level, laws governing animal welfare are widely divergent. Some states provide relatively good protection, at least for certain communities of animals within their jurisdiction, while other states have virtually no laws protecting animals. And of course, animals cross borders, whether on their own volition or transported by humans. As such, animals experience different levels of protection as they traverse from one jurisdiction to another, with no minimum level of protection afforded to them. Additionally, given the expanding global trade market, this patchwork of laws incentivizes a race to the bottom, with animal exploiters moving to countries that provide little to no protection for animals in order to improve their profits and arguably creating an unfair trade advantage. Thus, an international treaty that would set minimum global standards would help address these concerns. Slide number 3, please. Further, international agreements currently in force do not adequately protect well-being globally. To date, there are no international treaties that focus specifically on the protection of individual animals. The existing international treaties that do concern animals focus primarily on the preservation of endangered species or the management of commercially valuable species so that they will not become endangered. Perhaps one of the most well-known international agreements governing animals is CITES, the Convention on International Endangered Species of Wild Fauna and Flora. Notably, as the title suggests, CITES is a trade-focused treaty designed to preserve endangered species. CITES does not, though, provide specific protections for individual animals. Now, while CITES does require that, quote, any living specimen will be so prepared and shipped as to minimize the risk of injury, damage to health, or cruel treatment, unquote, this provision governs only international travel of threatened species. Notably, one international organization does address animal welfare. The World Organization for Animal Health, commonly known as OIE, passed a resolution actually supporting the development of a declaration for animal welfare in principle. Founded in 1924, the OIE has 6 main missions that are focused primarily on animal health and the control of animal diseases. But in 2000, its mission was expanded to include animal welfare. Since that time, the OIE has established certain standards, again, for certain animals. However, these standards are basically suggested guidelines, and they're not binding on any state. The adoption of an international convention on animal protection would provide for binding standards on those parties to the convention. Slide number 4. Advocates have been working to seek global protection for animals since at least 1978, when the Universal Declaration of Animal Rights was presented before the United Nations Educational, Scientific, and Cultural Organization. Almost 3 decades later, in 2005, the Universal Declaration on Animal Welfare was drafted, by a group of animal welfare organizations. These declarations lay out foundational principles regarding animal rights and welfare respectively. However, while the UN Food and Agriculture Organization has recognized the Declaration on Animal Welfare, neither of the declarations have really been formally adopted. Moreover, as declarations, they do not include binding obligations and are therefore distinct from a convention or treaty. The first draft treaty on animal protection, the International Convention for the Protection of Animals, was drafted by Professor David Faber back in 1988. And despite being presented to the World Society for the Protection of Animals and a potentially receptive country that might sponsor it, it failed to gain traction at the time. Much more recently, the Global Animal Law Association launched a draft treaty called the United Nations Convention on Animal Health and Protection. But to date, however, there has been no formal discussion of this convention by the United Nations. The problem, of course, is persuading nations that a convention to protect animals is needed. The recent pandemic has provided an opportunity to renew these efforts and persuade nations that an animal welfare treaty is needed by focusing on the interconnectedness of human health, animal welfare and health, and the health of the environment. Interestingly, what occasioned the creation of OIE was the emergence of rinderpest, or cattle plague, in Belgium back in 1920, when Zebu's cows from India were shipped to Brazil through the port of Antwerp. Now, perhaps some 100 years later, we may use another public health event to try to protect animal well-being globally. Slide number 5, please. The recent pandemic has demonstrated that the failure of society to address animal well-being has grave consequences, not just for animals, but directly for humans in our shared existence with animals on the planet. Wild animals carry viruses as reservoirs or hosts that may be transmitted to humans. In fact, it is estimated that about 75% of emerging infectious diseases are caused by animal to human transmission, or zoonosis. COVID-19 is only the most recent zoonotic disease. For example, HIV/AIDS jumped from chimpanzees to humans. Nipah emerged in Malaysia when humans had contact with pigs infected by bats. And initial outbreaks of the Marburg virus in Germany and Serbia were associated with laboratory work using African green monkeys imported from Uganda. Each of these examples demonstrates how human interaction with animals and their habitat influenced the spillover of these viruses. Further, subjecting animals to physical, mental, and environmental stress increases their susceptibility to contracting and thus transmitting disease. In sum, human use and mistreatment of animals, including the wildlife trade, human destruction of natural habitats, and intensive confinement of agricultural animals, harm the environment and animal welfare and puts human health at risk. Slide number 6, please. The unmistakable link among human health, animal health and welfare, and the health of the environment is widely recognized by the United Nations, the World Health Organization, and the Centers for Disease Control under the One Health approach. However, to date, efforts to implement the One Health approach have largely ignored the animal welfare aspect of that approach. CAP is designed to add this missing link. To be sure, each nation could unilaterally work to address these issues within their borders, but they have little incentive to do so because the risks borne by one state with regards to its treatments of animals is externalized, right? The harms upon all others. Animals, as well as viruses and other pathogens, don't restrict themselves to geographical or political borders. Thus, in light of an increasingly interconnected and globalized world, we must address animal well-being through global cooperation in the form of an international treaty. Slide number 7. Interestingly, in February 2021, a little over a year ago, the American Bar Association adopted a resolution urging all nations to negotiate an international convention for the protection of animals that establishes standards for the proper care and treatment of all animals to protect public health, the environment, and animal well-being. Now, although there are arguably many reasons for why prior efforts to secure global protections for animals have failed, one possible reason is that state leaders may not take animal organizations seriously. Of course, the American Bar Association is not an animal organization, and we are hopeful that having the ABA endorse such a treaty might persuade nation states to realize that adoption of a convention to protect animals is a reasonable, important, and necessary proposal, and not only the vision of animal advocacy. Now, notably, the resolution does not endorse any specific provisions for the treaty. Of course, the effectiveness of the treaty is a function of the provisions and its enforcement. So with the success of the ABA resolution, we began work on drafting CAP. Slide number 8. CAP uses an umbrella treaty approach, drafting a very general framework treaty that establishes basic minimal principles, and then providing for the addition of protocols in which specific and more refined animal welfare criteria may be established. Slide number 9, please. Since the goal is to ensure buy-in from countries worldwide that have different social, cultural, religious, economic, and political perspectives, we are working to craft very general provisions that are politically feasible while also improving legal protections for animals across the globe. A primary goal, at least, is to bring state leaders together to begin discussions to consider animal welfare on a global level. Nevertheless, a theme of CAP is the acknowledgement that animals are sentient beings with intrinsic worth and who are deserving of protection. The first draft of CAP was posted in October and was open for public comment until late February. We received extensive comments and are now working on substantial revisions. As such, the exact provisions are not yet final, but I do plan to briefly highlight a few of the intended provisions for the next draft of CAP. Slide number 10, please. The CAP opens with a preamble and statement of principles that explain why a treaty is needed and the primary goals of the treaty. Among these are the following. First, that humans and animals coexist within an interdependent ecosystem. Animals are an integral part of the environment, and the protection of animals and their habitat is an integral component of the broader concepts of environmental protection and conservation. Also, as I've mentioned, as sentient beings, animals have intrinsic value, and no animal, at the very least, should be killed unnecessarily or be subjected to cruel acts or to unnecessary suffering. And humans have an ethical obligation to act responsibly toward all animals. And when humans, have control over specific animals, they have a positive obligation to ensure their well-being. Slide number 11. The substantive provisions of the Umbrella Treaty will set very basic parameters for our treatment of animals, those under human control or care, as well as for wildlife and their habitat. The basic provisions allow parties to take into consideration their individual circumstances by indicating that parties, as far as possible, should develop law and/or policies that would ensure that the well-being of animals under human control include among the following. First, that those animals are protected against cruel acts or conditions, and providing the animal with suitable and sufficient food and water, adequate shelter from adverse environmental conditions, and an appropriate species-specific environment that allows the animal to engage in all natural behaviors. Regarding wildlife, we contemplate that each party, as far as possible, would maintain or establish a system of protected areas where special measures must be taken to conserve and protect wildlife. And in enacting such a system, parties should first establish management practices which result in the least suffering and killing of any wildlife. Develop, where necessary, guidelines for the selection, establishment, and management of protected areas where special measures may be needed to reduce the risk of pathogen spillover from wildlife to humans or domestic animals, and to promote the protection of ecosystems, natural habitats, and the maintenance of viable populations of species therein. Again, so as to ensure the good health of wildlife and reduce the risk of pathogen creation or spillover. Now, in addition to the text of the main umbrella treaty and these basic provisions, we do contemplate appendices that would set more specific provisions, but arguably are a bit more progressive and thus controversial, but that at least several of the parties could agree to without the need to go through the creation of a protocol, and which could be adopted by those willing parties at the first meeting of the parties when they were to adopt the full treaty. So, for example, some of the provisions in the appendices that we have in mind might include prohibiting fur farming, phasing out the use of live animals for the testing of commercial products, and or prohibiting the use, captivity, or training of wildlife when such activity is conducted primarily for the purposes of human entertainment. Slide number 12, please. Now, any party to the umbrella treaty may then coordinate with other parties to draft protocols to the umbrella treaty that would establish, as I said, specific and much more protective standards for the care and treatment of animals in a variety of particularized contexts. So, for example, we contemplate that there could be protocols that would address the transport of animals, live animal export, captive wildlife, companion animals, commercial animals, animals in research and testing, and animals in entertainment. So I'd like to end, if slide number 13, please, by reporting on a historic and groundbreaking resolution adopted at the UN Environment Assembly on March 2nd of this year, just a couple of weeks ago, entitled Animal Welfare, Environment, Sustainable Development, Nexus. The resolution expressly acknowledges the need to address the connections among human health, animal welfare, and the health of the environment through the One Health approach. And it requests the executive director of the UN Environment Program to produce a report on this nexus. This resolution is the first resolution to be tabled and adopted at UNEA with explicit reference to animal welfare, and it signals an appreciation for and interest in addressing animal welfare on a global level in order to promote the welfare of all living beings on our planet. And we are hopeful that this is the first step towards the realization of a convention on animal protection. Slide number 14. Thank you very much, and I'm looking forward to your questions.
Thank you, Professor Schaffner. Next, we'll wait. I forgot to mention that we'll wait for the end of the presentations for question and answer. And please feel free to type in your questions in the chat if you would like. Oops, excuse me. That was my timer for the presentation. So if you would like, you can type in the questions in the chat, and then I will read off the questions for the panelists. Professor Winders, would you like to go next, please?
Yep, thank you so much. So I am going to build off of Professor Schaffner's presentation and talk about one example of an international convention, the CITES, or the Convention on International Trade in Endangered Species, and how that is applied through one nation's laws, the United States Endangered Species Act, and specifically how that act, the ESA, has been applied to captive wildlife, and how the attention to captive wildlife, the well-being of captive wildlife, is directly bound up with conservation of animals in the wild. So I'll start with an overview of CITES and then an overview of the Endangered Species Act. I'll then talk a little bit about the relationship between captive animal welfare and conservation, because it may not be obvious or intuitive. And then I'm going to share a couple case study examples of ways in which the Endangered Species Act has successfully helped captive wild animals. So if you can go to the next slide, please. Thank you. So as I said, CITES is the Convention on International Trade in Endangered Species of Wild Fauna and Flora, specifically is the full official name. And this is a international agreement between countries that was intended to ensure that international trade in both animals and plants does not threaten species survival. So CITES was drafted after a resolution came first in 1963 at a meeting of the IUCN, the World Conservation Union. So members agreed initially to a resolution, and then eventually this became a convention. And so some years later in 1973 in Washington, D.C., 80 initial countries agreed to CITES, and that went into effect 2 years later in 1975. And so international wildlife trade is a multi-billion-dollar business. It is vast. It includes not only live animals and plants, but also products made from animals and plants for medicine, for food, for display, for a host of purposes. And so it was a vast industry even then, but the idea of regulating it was novel. Today, nearly 40,000 species of animals and plants are protected under CITES, and they're given varying levels of protection depending on how imperiled the species is. So it can range from a total prohibition on trade in those species to a much more lightly regulated trade. But it's important to know that CITES is a voluntary agreement. So countries that agree to become a part of it are referred to as members or parties. And once they agree, they have to implement the convention through their own national legislation. So each nation that becomes a party has to put its own laws into place. So as I mentioned, initially 80 countries were parties. That included the United States as a founding party. China became a party in 1981, and today it has expanded significantly. So there are 184 parties. So next slide, please. I'm going to turn to the Endangered Species Act, because the Endangered Species Act is the U.S. law implementing CITES. So this was originally enacted in 1973. It has been amended a bit over the years. It is distinct from CITES because it is a law implementing CITES, but it very much overlaps with CITES. So under the U.S. Endangered Species Act, more than 2,000 species are covered. About a third of those are foreign species, species that are not native to the United States. And the Endangered Species Act has a listing process, which is by statute supposed to be based on the best available science and commercial data, because there was concern about industry influence and not relying on science. So even back then we recognized that. And once a species is listed as either endangered or threatened, there are a range of protections that come into play, prohibitions on what you can do with members of those species, and requirements for habitat conservation, habitat protection. So the prohibitions include importing members of protected species, exporting, transporting, and interstate and foreign commerce, selling or offering for sale, as well as take, which is defined very broadly. It includes harming, harassing, wounding, in addition to things like capturing, trapping, and killing. And the United States Supreme Court has made very clear that this prohibition is meant to be interpreted very broadly. And it's the take prohibition that comes into play most often when we're talking about captive wildlife. So another key component of the U.S. Endangered Species Act is that it has a citizen suit provision. It has a provision that allows not only the government to enforce the law, but private individuals, private organizations to go into court and sue to enforce the law against private parties, and to sue the government when they're not upholding their responsibilities under the Endangered Species Act. And that's a common provision in our federal environmental laws in the United States. And it's a really key component to ensuring a law that can be meaningfully enforced, because you're not relying on the state, giving the state a monopoly on enforcement. There's a supplementation. It should be a supplementation, not a total replacement for government enforcement. But either way, it's really important to have mechanisms like this. And so, we generally think of the Endangered Species Act as protecting animals in the wild and their habitats, and that is absolutely a key component of this law. But it has never been disputed fundamentally. It's been clear on the face of the law from the beginning that it also applies to captive members of protected species. And the agencies that are tasked with enforcing the Endangered Species Act have really struggled with how to do that. And that's partly because although the ESA has a host of prohibitions, it does not prohibit possessing members of protected species. It prohibits harming them or harassing them. And there are certain species of animals, particularly wide-ranging animals, animals who have very complex needs, who it's very difficult to hold in captivity, even under the best of circumstances, without harming them or harassing them in some way. So there's been this constant tension and effort to regulate around that tension. But the bottom line is possession itself is not prohibited, but harming or harassing animals, including captive animals, is unlawful under the Endangered Species Act. So next slide, please. So what do captive animals have to do with conservation, with protecting animals in the wild? So first, I want to talk about what they do not have to do with animals in the wild, because we often hear the assertion that there's some direct connection between animals who are bred in captivity and repopulation in the wild. That is not common. That is the exception. It's an extremely rare exception, particularly if we're talking about mammals. So fewer than 6% of attempts to reintroduce captive bred animals into the wild have succeeded. And for most species, it isn't even attempted. Most animals who are bred in captivity are done so with full knowledge that there will never be even an attempt to release them into the wild. So it's very important to understand that most captive breeding around the world is not about repopulating in the wild. And this underscores the critical importance of maintaining habitat in the wild and maintaining the animals who are in the wild. It's also important to understand that most captive bred animals lack genetic integrity, and if they were released into the wild, could actually harm wild populations. Tigers are a really good example of this. So in the United States, we have more captive tigers in private ownership in American backyards, basements, and bathrooms than there are left in the wild worldwide. The reason for this is because we continue to allow things like cub petting, which requires a constant supply of young cubs who are then discarded once they become too big and dangerous to handle. But these animals are mixed subspecies. They are what some refer to as generic tigers or hybrid tigers. The United States Fish and Wildlife Service, which implements the Endangered Species Act, has recognized that they have no genetic integrity. They are not a type of tiger who you would encounter in the wild. There is no effort to maintain genetic integrity among these animals. So it's important to understand that. And then white tigers like Kenny, who you see here on the slide, is particularly problematic, particularly emblematic of the inbreeding that happens. So there's inbreeding across the board among captive tigers, captive lions, and then attempts to hybridize across those species. But white tigers are a particular problem. So first, it's important to understand that white tigers are not a species that exists white tigers are the result of inbreeding. They are the result of forcing relatives who carry a recessive gene to mate so that they have this display of white fur, which is not typical in a tiger. And so Kenny was born to a brother and sister. He was born with a cleft palate and crossed eyes. And he died. He did actually get to go to Sanctuary. He went to Turpentine Creek Wildlife Refuge, but he died at about half the normal life expectancy of a tiger because of all the health problems he faced as a result of the inbreeding. Neonatal mortality among white tigers is reported to be as high as 80% or maybe even more. They're at significant risk of the kind of facial deformities that you see here with Kenny, as well as a host of other problems, depth perception problems, retinal degeneration, cataracts, mental impairment, kidney problems, heart problems, spinal problems. It goes on and on and on. And so breeding is directly impairing the gene pool as well as the welfare of these individual animals. So another argument that you often hear is that by exhibiting captive wildlife to the public, we can help conservation. We can get people invested in preserving animals in the wild. So the truth is that there is no evidence of this. There have been many attempts to demonstrate that exhibiting animals is educational and translates into changed behavior that is more beneficial to conservation. The efforts have not been able to prove that this is true. Not a single study has demonstrated lasting positive behavioral change resulting from education through animal exhibition. However, it does seem that the opposite may be true. That observing captive wildlife, especially if you do so when they're in direct contact or close proximity to humans, can undermine legitimate conservation efforts. So a number of peer-reviewed studies have found that exhibits, particularly where humans are in close contact with captive wild animals, can make people believe that the populations must be stable and healthy, because otherwise these activities wouldn't be happening, and in turn make them less likely to donate to conservation. As two tiger experts, Phil Nyhouse and Ron Tilson, explained, quote, "People watch the films, they visit the zoos, and by the mesmeric power of these vicarious experiences, they come to carelessly believe that the species is alive and well because they have seen it." So these are just a few examples of the relationship between captive wildlife and conservation. I did also want to flag another related issue, which is something that we've been working on in the Animal Law and Policy Institute, which is the use of captive animals at substandard facilities for so-called wildlife photographs. So you may be surprised to learn that many of the photographs you see on calendars, in stock photos, are actually not of animals in the wild. They're of animals at shoddy facilities that are holding the animals captive to allow them to be photographed in situations to make them appear like they are in the wild. So what can we do about this situation? What I want to turn to next, if I could go to the next slide, is some examples of how the U.S. Endangered Species Act has been used to advocate for captive wildlife and to end practices that are harmful both to individual captive animals, but also to efforts to preserve these species across the board. And so the first example I'm going to talk about is Tim Stark, who you see here, who operated a facility for many years called Wildlife in Need in Indiana. And so Tim Stark would use tigers and lions and hybrids for what he called tiger baby playtime events, where cubs were passed around for public encounters and photo opportunities. This was extremely stressful for these animals who should have still been with their mothers. They were pulled from their mothers very shortly after birth in order to get them used to being handled by humans when they should have been with their mothers, including to get to develop their immune systems. He would also declaw these animals to make them easier to handle. And declawing is an extremely invasive procedure, which involves cutting off, amputating at the first knuckle, essentially. It's very painful, and Wildlife in Need did not provide pain relief for these animals. It is also causes long-term psychological and behavioral problems because animals, big cats rely on their claws. So under the Endangered Species Act, PETA sued, and under the citizen suit provision, and challenged specifically the declawing of these cats, the premature maternal separation, and the use of them in public encounters. And that was successful. They were able to rehome the cats who survived. Unfortunately, there were some who died, likely as a result of complications from declawing procedure. But those who survived were able to go to a sanctuary. He was prohibited from continuing to engage in these behaviors and ordered to pay hundreds of thousands of dollars to PETA. It also prompted other government agencies to step in and help the animals who were not protected under the Endangered Species Act, and he is now shuttered. We can go to the next slide, and I will go quickly because I know we're running close on time. This is just one other example, and there are quite a few, and they're discussed in detail in the book chapter that I showed on the earlier slide, where I, with some of my colleagues, have given a comprehensive overview of the Endangered Species Act as applied to captive wildlife. But the last example I'll share is a suit against Dade City's Wild Things, which was a similar operation in Florida, which used cubs, removed them even just hours after they were born, forcibly took them from their mothers to use them for public handling, photo ops, and swim with the tiger events where tigers were forced to swim with members of the public. Here again, the lawsuit was successful. The animals were rehomed, and Dade City Wild Things is now shut down. And so some of the worst players in this arena and those that were supplying the massive influx of tigers in the US have been shut down thanks to private use of the Endangered Species Act. So the last thing I want to touch on is, if we can go to the next slide, what happens with these animals once you are successful and able to remove them from these owners who are exploiting them. So thankfully, there is a network of accredited sanctuaries, not only in the United States, but around the world. So the Global Federation of Animal Sanctuaries, or GFAS, is the gold standard accrediting body. It's a third-party accrediting body for sanctuaries. It has rigorous standards, and you can go to their website, sanctuaryfederation.org, and look up if a particular facility you're interested in is accredited, and also look for facilities in a particular area, a country, or a state. If we can go to the next slide, please. One of the sanctuaries that has taken in a great number of these animals is the Wild Animal Sanctuary, a GFAS accredited sanctuary in Colorado that has taken in not only the animals from Dade City Wild Things, a number of them, and Tim Stark, but also some of the other players who were featured in Tiger King, including Jeff Lowe, who the Department of Justice brought suit against, citing the precedent that had been secured by PETA in the cases that I've been talking about, and used that to successfully remove almost 100 endangered animals from Jeff Lowe and a permanent prohibition on his ownership of endangered animals. So I do want to flag that there is an increasing prevalence of pseudo sanctuaries, facilities that are calling themselves sanctuaries but are actually harmful to animals. And so that's why things like this accreditation is so important. But some red flags to look out for are public encounters with the animals and allowing animals to breed, because we already have more animals in captivity than we can provide proper housing for. And as we've talked about, there is no conservation value in continuing to breed these animals. So just to wrap up, this is sort of a case study example of how an international law translates into federal law and can be used to protect both captive wildlife and wildlife in nature, and has had some successes. It's not perfect, there's still a lot of work to do, but I think it has been a really useful tool. Thank you.
Thank you very much. So we are already getting some questions, so I would encourage people to continue to type in their questions, and we will answer, ask the panelists afterwards. Thank you very much for both of you, the speaker. Now we turn to Professor Qian Yefang. She will talk about the laws in China. Oops, that's Professor Qian. Oh, one more thing, I would like to also acknowledge that the two superstar interpreters who have been helping us interpret, it's Mengxing and Echo. Thank you very much. 钱老师，你可以开始。
我现在可以开始了啊！我这个摄像头不知道怎么回事啊，只剩下一半了。非常感谢我们这个佛蒙特法学院和上海交大赵慧宇教授的邀请，也非常感谢前面2位教授的分享啊，分享的从国际公约到国内法。那么我在这个基础上讲我们中国的国内法当中国家法和地方法之间的一个冲突的问题。我的切入点是犬类屠宰国家法和地方法的冲突。我将沿着这样一条线来进行。下一页。中国动物保护的时代背景。中国国家法对犬类屠宰的许可。地方法方面呢，讲吉林省地方法规对犬类屠宰的许可最后呢对这样的一个冲突做出一个建议。下一页。那么关于我们中国动物保护的时代背景，下一页。中国已经进入了生态文明与全面依法治国的新时代。生态文明建设应该说是我们中国特色社会主义事业总体布局的一个关键的环节。习近平总书记在他的生态文明思想的核心就是坚持人与自然和谐共生，人与自然是生命共同体，那么其中必然蕴含着人与动物和谐共生，人与动物是生命共同体的这样一个理念。所以众所周知，动物是生态文明中青山绿水、生态系统、生物多样性的重要构成元素，所以动物文明是生态文明的一个重要的部分。那么这个是中国动物保护事业的一个推进的一个时代背景。那同时中国也已经进入了全面依法治国的新时代。全面依法治国需要的是坚持依法治国、依法执政、依法行政共同推进。那么这个依法执政和依法行政就涉及到中央政府和地方政府的这样一个执法问题。那这是中国动物保护法治推进的一个时代背景。我们看下一页。那么在这样的一个时代背景之下，我们中国动物法体系也在不断完善，动物文明法治化程度也在不断提高。例如在野生动物保护法的多次修订过程当中，生物多样性、生态文明上升为法律概念和法律理念。而在动物防疫法的修订过程当中，文明养犬、流浪动物控制也上升为法律制度。在2021年8月份发布的这样一个有一个《中华人民共和国实验动物管理条例》修订稿的一个征求意见稿当中，也史无前例的将动物福利上升为法律概念。 特别是2001年5月，农业农村部公布了国家畜禽遗传资源目录，在这个目录当中将犬类移除，宣告犬类的伴侣动物的地位。那么这个跟我们今天的我的这个发言就密切相关了。再看下一页，下一页。所以说在这样的一个时代背景之下，我们的中国的动物保护问题依然是非常严重，我们的中国的动物法的体系还是不够完善。那首先呢，我们是缺少一部一般性的动物保护法，或者我们说叫动物保护一般法，或者说我们没有反虐待动物法，也就是说现阶段中国仍然没有实质性的法律去遏制虐待动物的行为。那么其次，在分类立法当中，我们是缺少伴侣动物专门立法，也就是犬和猫这两个物种的专门立法。其他的这些物种野生动物、农场动物、实验动物，我们都有专门的法律或者是政策去引导，唯独没有伴侣动物专门立法。这个呢，恰恰是中国动物保护问题的核心所在，因为伴侣动物与人类的关系非常特别，与其他的动物其他类的动物相比，所以伴侣动物它得不到保护，我们就谈不上说其他动物的保护会能够保护到什么样的一个程度。但这里面呢，其实也有个误区，中国的伴侣动物它并不是没有任何的保护，那至少有一条世界通行的保护底线我们是守住了，也就是禁止屠宰食用伴侣动物。所以今天要讲的就是伴侣动物屠宰上面我们中国国家法与地方法的一个冲突的问题。所以我们先来看国家法层面。下一页，翻到下一页。我们在国家法层面呢，有一部动物防疫法，它对所有动物提供了一个一般性的保护。上一页上一页，不要到下一页，再往上，对，不是往上，不是往上，这是下，往回，对，到这里，不要动了不要动了，往下，下一页。对，所以我现在要讲的是动物防疫法对动物的一般性保护。因为这部法明确规定，禁止屠宰经营未经检疫的动物，那么这些动物当中包括伴侣动物。在动物保护的问题上，国际社会其实对我国一直都有批评，都有诟病。所以我们看到外国人嘲讽中国最常见的一句话就是他们是吃狗肉的，但其实这是一个误区就是实际上至少在立法的层面，我国与世界卫生组织和绝大多数国家一样，没有制定犬猫屠宰检疫规程，我们采取的是间接禁止食用立法模式，也就是禁止屠宰、切断市场供给这个是跟绝大多数国家一样的。再看下一页。那么原农业部在2006年提交国务院批准的中国畜禽遗传资源目录，它有个送审稿，在这部送审稿当中，原农业部在认真查阅了大量的字典、词典、文献资料以及国外立法之后，慎重的给畜禽下了一个定义。那什么叫畜禽呢？指在人工饲养环境下能够正常繁殖、生产肉、蛋、奶、皮、纤维、药材等产品及用于使役动物伴侣等功能的畜禽。所以这里有伴侣两个字。对，正因为这样，所以当时这个送审稿当中把犬和猫作为伴侣动物列入了其中。但是在2008年 正式出台的这个目录当中，猫是被移除的，犬留了下来。那到了2020年5月29日，农业农村部公布了一个新的国家畜禽遗传资源目录，在这个目录当中，犬也被移除了。也就是说，现在在国家畜禽遗传资源目录当中，猫和犬都不在了。那畜禽的这个概念就被相应的调整为为人类提供肉、蛋、奶、皮、纤维、材料等产品及用于使役运动的畜禽。伴侣2个字也被排除掉。所以说这个伴侣动物跟畜禽在我们农业农村部的里面，它是一个完全不同的2个概念。下一页。同时，农业农村部表示，这个畜禽遗传资源目录它属于正面清单，列入的动物归畜牧法管理。犬虽然没有列入清单，但也不是野生动物，并不意味着不能养，就是说可以养的。那什么叫正面清单呢？也就是定义当中所说的为人类提供肉、蛋、奶、毛皮、纤维等产品，或者满足应用、运动等需要的动物清单。所以这里面就没有伴侣动物。可见农业农村部界分的非常清晰，犬和猫作为伴侣动物，它不是为人类提供肉的，它是发挥它伴侣的功能。实际上，国务院农业主管部门早就将犬和猫从食用类动物当中排除，所以它既没有制定犬屠宰检疫规程，也没有制定猫屠宰检疫规程。所以这个犬和猫它作为伴侣动物，不是作为肉类来提供的伴侣动物，在国家立法的层面，以及在国务院国务院的农业主管部门的层面，它是非常清晰的。但是到了地方就变得非常的混乱。我今天是以吉林省为例，讲这个地方法规与国家法的冲突的问题。那下一页。那么吉林省它是一个多民族的省份，其中既有禁食狗肉的民族，也有传统上吃狗肉的朝鲜族。所以我们可以看到，禁食狗肉的民族比传统上吃狗肉的民族它有多得多啊，其中还包括汉族啊。但汉族它这个问题我们后面再看，它是一个多民族的省份。所以我们再往后看，在2006年的时候，吉林省人大通过了《吉林省畜禽屠宰管理条例》。这个条例当中，它创造出一个概念叫食用犬。食用犬，它把犬类作为畜禽，是可以食用的畜禽，可以屠宰的畜禽纳入其中。那么它的法律效力是覆盖全省的，那么既覆盖到吃狗肉的少数民族，也覆盖到不吃狗肉的少数民族以及汉族。2017年，吉林省制定了食用犬屠宰动物卫生检疫规范、检验规范。而根据《动物检疫管理办法》制定屠宰检疫规程的权利是属于国务院农业主管部门。而农业农村部认为我国是不宜制定犬类屠宰检疫规程，而且没有授权任何地方政府部门制定犬类屠宰检疫规程。那么在这种情况下应该怎么办？吉林省它没有权利制定吉林省犬类屠宰检疫规程，所以它就用这个卫生检验规程来替代屠宰检疫规程以便实现合法的屠宰。下一页。那么在前面讲的2020年新的这个国家畜禽遗传资源目录公布之后，全国人大常委会法规备案审查室给各个地方的人大常委会也发出通知，要求清理在地方法规规章当中有关犬类屠宰的规定。但是我们看到，在2021年5月修订的《吉林省畜禽屠宰管理条例》当中，并没有按照这个全国人大法规备案审查室的要求清理犬类屠宰的规定， 它是保留了关于屠宰使用权的规定，所以我们应该是知道的，法规备案审查它是一项非常重要的宪法性制度，它没有对吉林省进行一个省级的豁免，所以在这一种情况下，我们的法规备案制度处于一种无可奈何的状态。那这个呢，让中国的这个动物保护问题也处于一个非常尴尬的这样一个境地。下一页。好，下一页。所以这就是我们看到了国家法与地方法之间的一个冲突，而这个冲突呢，它是以民族习惯作为一个冲突的这样一个怎么说呢就是因为这个民族习惯问题，所以导致这样的一个冲突。所以如果说不划清民族习惯的边界，不能够正确处理民族习惯与依法治国之间的关系，那肯定会损害社会主义核心价值观，尤其是损害社会文明与和谐、公正与法治。我们全国人大和农业农村部也一再强调，保护动物、反对虐待动物是社会文明进步的重要标志。所以在这样的冲突的情况下，因为我们刚才说的这个吉林省，它为什么要制定这样一个东西？那么它的理由就是说要尊重民族，就是少数民族的狗肉传统。所以这样一个尊重传统跟我们全面依法治国战略之间发生冲突的时候，应该怎么办？实际上，这个现行的法律已经提供了解决的方案。就我们动物防疫法是禁止屠宰经营伴侣动物，但是这部法并没有对消费性的食用施加法律惩戒，也没有禁止自养自食。那么这样的规定是完全可以满足少数民族食用狗肉的需求。我们将这样一个习俗或者文化限制在少数民族自治区，而不是把它扩大化到一个全省的范围之内，那么这样才是适当的，这样才算是既尊重了民族文化，也尊重了法律。好，所以说后面呢，我们需要做一个建议。下一页。所以我的建议是说要在吉林省，第一，在吉林省畜禽屠宰管理条例及其配套措施当中，将有关食用犬的规定的适用范围限制在少数民族自治区，或者说由少数民族自治区自行去制定与屠宰食用狗肉相关的单行条例，来保持其本民族的一个自养自食的文化传统。这是在吉林省的一个少数民族，就是朝鲜族自治区内可以做这样的一个设计安排。另外，在朝鲜族自治区之外的地方，朝鲜族民众你可以自养自食，但是禁止屠宰销售，禁止商业操作。那么这样就可以避免动物防疫法它在全国统一的这样一个法律效力。所以我们看到这个动物防疫法因为这个吉林省地方条例的问题，导致我们动物防疫法它，因为这可以说这是一个蝴蝶效应当然说这个蝴蝶效应我是打了引号的，它还有一个理论叫破窗效应，也可以引用这个理论来。怎么说呢？就是说因为吉林省的这样一个示范，它也导致我们全国其他的地方在就是动物防疫法的关于禁止屠宰销售犬猫的这样一个强制性的规定，在这样一个规定在全国其他地方也失去了效力，就是说动物防疫法的这个规定在犬猫问题上也失去了效力，这也导致我们中国的这样一个动物保护法、动物保护一般法或者说法律的动物法很难进入立法计划，因为吉林的这个规定，它使得犬猫的屠宰问题跟民族习惯关联起来，变成了一个非常敏感的问题，所以这个导致我们这个动物保护的立法遇到了障碍。所以这个应该说只有解决了这样一个关系的问题，我们能平衡好尊重民族传统与依法治国的关系，那我们中国的动物保护的事业，或者说中国动物保护法治的发展，才能够取得突破性的进展这个以上是我的一个观点，谢谢大家。
Thank you very much, Professor Qian. Okay, I'm going to turn off my timer, sorry. Everybody actually presented within the time frame, so we have some time for question and answer. Thank you very much. There are a lot of actually questions all written in Chinese, so I will turn it over to either Xiaoyu or Yanmei to read them off.
Yes, thanks, Shiteb. So I will read the Chinese, and then the interpreter will translate the questions simultaneously. So the English speaker can stay in the English channel, and the Chinese listener just stay in the Chinese channel. 所以第一个问题呢是想请教Professor Delcy Winders， 美国濒危物种法里规定个人或法人可以提起诉讼的法条具体是怎么规定的？起诉的案由有哪些？哪种条件才可以提起这个诉讼？
Yeah, great question. So the Endangered Species Act's enforcement provisions, which are in 16 U.S.C. section 1540, if you want to look at them. So there are a host of mechanisms that are available. So the government can bring criminal enforcement, the government can bring a civil suit, but also very importantly in 1540 subsection G, is the citizen suit provision that I was focused on and that has been used by NGOs. And so what that provision provides is it's a civil action to seek injunctive relief. So basically to stop someone from doing something that is harming animals or harming habitat, or to get them to do something to improve the situation. And so that has been used to get injunctions to prohibit specifically harmful behaviors, and to remove animals from situations where they are being held in conditions that violate the law, as well as some possession bans have been put in place. Basically, an agreement that they're never again going to hold animals who are protected. And as I mentioned before, the statute doesn't specifically prohibit possession, but that can be part of, courts have wide discretion in crafting injunctive relief. So that can be part of the relief. And so the way the mechanism works is there is a 60-day notice requirement. So before you can bring suit, you need to send notice to the defendant, the prospective defendant or defendants, and put them on notice that you intend to sue, why you believe the law is being violated. You also need to include the government agencies that have the ability to bring enforcement action, to give them an opportunity to step in if they want to. If they do not, which is almost always the case, then after the 60 days has run, you can bring the civil suit, and you're not going to get monetary relief. The money that I mentioned that PETA got was for attorney's fees. So attorney's fees are available if you prevail, but you can't get fines. You're not going to be able to, incarcerate someone, but you can get injunctive relief. And that's really mostly what those who are trying to help animals want to get, is to improve the situation for the animals and to prohibit behaviors that harm animals. So I hope that answered the question.
一个就是跟踪的问题，就是在这个公民诉讼里面，关于这个起诉资格是不是必须要遵循美国宪法的第3条的这个 standing 的要求？如果个人无直接受害的话，可不可以？
Excellent question. So yes, any suit brought in federal court in the United States needs to meet the requirements of Article 3 of the Constitution. It's a jurisdictional provision, so the court lacks jurisdiction if that isn't met. And the way that the U.S. Supreme Court has interpreted that is to require that the plaintiff suffer an injury that is caused by the challenged behavior, and that the court has the ability to redress. It's also important to keep in mind in this context, if you're seeking injunctive relief, the injury needs to be ongoing. You can't only rely on a past injury. There needs to be an ongoing injury that the court has the ability to correct. And so, as you can imagine, standing is a early battle that we fight in almost all of our animal law cases in the US, at least if we're in federal court. And the primary ways that the courts have recognized standing in the Endangered Species Act litigation on behalf of captive wildlife, there are two. So one is based on an aesthetic harm to an individual who likes seeing animals in humane conditions and is harmed by the inability to do so by witnessing animals in inhumane conditions. So there's a growing body of case law recognizing that. And then the other is organizational harm to an organization itself, for an organization to have standing in its own right. And the leading Supreme Court case on that is Havens Realty versus Coleman. And that basically provides that if an organization's core missions and activities are thwarted by the unlawful activity, and they are forced to divert resources to counteract that, then that is sufficient for standing. And that has been used with a lot of success in recent years by animal protection groups. And that was the basis for standing in both of the lawsuits that I talked about today.
第三个问题是给第一位发言人的，他的问题就是说，这个提议中的动物福利法的国际条约，它的怎么样来平衡动物福利和人类福祉之间的这个价值？就在这部法里面，有没有提到它在保护动物福利和人类福利之间的这个关系？
Hi, thank you for that question. When you say balance, I think the idea within the concept of One Health, the One Health approach, is that human welfare and public health are inextricably intertwined with animal health and welfare, as well as, of course, with the health of the environment. So the concept here, and of course, primarily when we deal with these public health events, most international organizations and even laws within the countries focus primarily on human health and the public health issue and the disease spread and ways in which the disease is spread. Often after, of course, the disease has been transmitted from the animal to the human, and we're dealing with that, right? And so if I'm thinking about it from a public health perspective, the idea here is that if we promote greater well-being and provide greater protections for animal welfare and animal well-being, we will in fact improve human health and well-being because of that interconnectedness. If it's on the one hand, there'll be much less opportunities if we don't directly engage, for example, with wildlife in inappropriate ways. There'll be less of an opportunity for the spillover of the disease from the wildlife, from the wild animal to humans, or within the agricultural area, right? If we don't have intensive confinement of agricultural animals, there's less of an opportunity for disease to both be created and be spread to humans. So the concept, but we don't. The concept is that by protecting animal health and welfare, we're in fact going to be promoting public health as well. So when you talk about the balance, I don't know that there's like, the more we protect one, the less we protect the other. The great concept behind the One Health approach is that by protecting both human and animal well-being and health, we actually improve both simultaneously. The concept though behind CAP and some of the previous treaties that I mentioned that had been developed in earlier years, although they didn't focus on this One Health concept, by promoting animal well-being and proposing provisions to promote animal well-being, they in fact, right, were implicitly also designed to improve public health and environmental health as well because of that interconnectedness. I hope that answers your question.
Thanks a lot. 谢谢。其实，在我们的这个聊天窗里面，有很多同学和老师在讨论这个第三位发言人的这个主题，所以我想大家有兴趣的话可以看一下。但我在这里翻译 第一个提这个问题的同学，他想问这个传统文化是不是需要随着时代而更改或者进步？比如说吃狗肉，然后其实Peter 李老师其实也回答了一下，是在2017年在一个朝鲜族的调查当中，狗肉已经不是朝鲜族的这个主流饮食文化了，所以就是关于食狗肉这个，钱老师提到，可以为了尊重这个民族的文化，在地方法可能可以限制在一个程度，可能需要你来回应一下。另外一个问题，其实他有一个同学问到，不是很理解为什么伴侣动物要按照物种来划分，所以请钱老师来大概回答一下，或者就是回应一下，
静音我现在解除静音了。就是关于传统文化，我们知道传统文化它也是在不断更改、不断进步的，包括韩国的这个狗肉文化都已经在被法律所改造吧。那我看到一个说狗肉是汉民族的传统，为什么不尊重？其实我们可以想一想，这个野味是不是也是汉民族的传统？为什么我们现在要禁食野味？所以我今天并不讲我这个问题啊，我不从这个动物福利或者说生物多样性或者说这个生态平衡的角度来讲，那么我们仅仅是从那个刚才前面那位教授讲的那个动物防疫，就是人畜共患病以及法律规定来讲，这个人畜共患病，我们知道它越来越流行。那我们现在正处在新冠大流行的这么一个时代背景之下，如果说我们还在考虑说这个传统的狗肉要不要吃的问题，真的是太不合时宜了。因为这个动物防疫人兽共患病，一个前提就为了预防这个人兽共患病，保障公共卫生健康，所以呢，世界各国它才会有一部法叫动物防疫法。对吗？动物防疫法，那么所有的动物，你只要吃到嘴巴里面，你首先就要防疫。所以呢，在这种情况下，我们猫和狗，野生动物是没有办法制定屠宰检疫规程的，所以野生动物你是不能吃的。你吃了之后，就可能会导致这个人兽共患病的流行。这个我们应该是现在是正在经历的这样一个阵痛。另外就是狗和猫它也是，我们也不要说追问说为什么不制定全屠宰检疫规程，猫屠宰检疫规程，那么从那法律规定上面它就是没有规定，那么我们就不能屠宰，这是依法治国的一个必然的要求。你没有规定，你当然不能屠宰。但是说为什么你为什么国家说不能屠宰？但是说除了说跟世界接轨之外，其实我们本民族在传统文化当中也有说这个猫和狗它跟人类之间的这种特殊的关系它这里面实际上受到一个动物伦理的问题这个我们就不从道德方面来回答这个问题了。所以呢，我总结一下，就是狗肉为什么我不说狗肉为什么不能吃这里面还有两个概念一定要分清楚。我们不是说狗肉不能吃，我说的是犬和猫不能屠宰销售，也就是说它是在一个间接进食，它不是直接的进食。因为我们会发现世界上绝大多数国家都是这种间接立法模式，就是说你不能够，其实你交易是违法的，但你是吃就是消费不是消费行为或者说是自养自食，很多国家它是没有禁止的。所以我们中国的立法也是这样一种模式，间接禁食，就是你不能屠宰销售。为什么我刚才说就是说朝鲜族少数民族完全可以在法律之下去保持它的这样一个这个狗肉文化传统呢？因为我们的法律也是说没有禁止你自养自食，它禁止的就是屠宰和销售。所以呢，我们说屠宰的行为以及市场上销售的行为，它是违法的，是需要接受法律惩戒的。但是你去消费，或者说你自己养自己吃，目前是没有法律进行一个惩戒。但是说后面我们要不要把我们的目前的这种间接进食的模式把它转变为直接进食的模式，也就是说直接规定禁食狗肉，要不要这样做？那么这是后面需要进一步探讨的问题。 实际上我们台湾地区、香港地区和澳门地区，它采用的就是一种直接禁食，它直接规定禁止食用狗肉，你食用了就会接受法律的惩戒。但我们大陆地区要不要同步，那这是后面的问题。现在我们强调的是说，在法律的层面，在依法治国的这样一个时代背景之下，我们要不要尊重法律？我们要不要依照法律来禁止屠宰和销售？好，这是我的回答。
非常感谢钱老师，我看时间已经差不多了，所以我把这个我知道还有挺多的问题在这个聊天窗里面，那我到时候可以翻译给老师，可以在这个聊天窗进行回答。但是我把这个主要的时间交回给主持人。
Great. Thank you so much. I really appreciate this lively discussion, and I think it actually tells us that we would like to do more of these exchanges and understand each other's laws and cultures. And I mean, this is a great panel looking at from the global perspective to national and then local, and also, you know, taking into account traditional uses of animals. So I will turn this, and I hope that we will continue to have these collaborations, but next, I would like to turn the panel to the next panel moderated by Professor Yan-Mei Lin, and it's going to be focusing on comparative comparison of the different laws in the different countries on these issues. Thank you very much.
Yes, thank you, Sutip. So we are really honored to have the world-class expert to join us for this webinar, and have so many participants that really interested to join us, and apologize again that we only have 100 participants limit for this meeting. So since we have generated so much interest, so well, we will definitely put the recording of this event to our law school's website, so stay tuned. So that, as Sutip mentioned, the panel 2 focusing on comparative wildlife law, that looking at 3 jurisdictions, China, Australia, and EU. So we have 3 great experts on, they are all expert in their jurisdiction. The first speaker is Professor Huiyu Zhao, or Zhao Huiyu 老师. Her English name is Joy. So really happy to have her. She is the Associate Professor of Environmental and Natural Resource Law at Koguan School of Law, Shanghai Jiao University. She's also a visiting professor of law at the University of Maryland and Vermont Law School. So she actually is our summer faculty in at least 2 or 3 years. And she's also hosts a temporary post in the procuratorate and the Environmental Protection Bureau in Shanghai. So she has very rich practice experience in addition to her great scholarship. The second speaker is Professor Deborah Cao. Professor Zhao is a professor at Griffin University in Australia. So she's a legal scholar and also a linguist. She's a leader in the areas of animal law and animal ethics and welfare in China. And she's also an expert in legal translation between Chinese legal language and culture. The third speakers are a teamwork. Professor Alice DeConstato. She's the founder of the European Institute for Animal Law and Policy and lecturer in European Animal Law at Sorbonne Law School and Science for Law Schools. And together with her is her students, Mila Arabas Shuvia. She's the student at Sorbonne Law School, where she's now completing her final year of master degree in European and Agriculture Law. She's also an intern at the European Institute for Animal Law and Policy. So without further ado, I would like to give the floor to Professor Zhao. She's the first speaker, and she's now sharing her screen. Thanks, Professor Zhao. The floor is yours. I think you need to unmute yourself.
Oh, here. Okay. Oh, I don't know how to open the voice. Sorry. Okay. Thank you so much. Thank you, Vermont Law School, to invite me to take part in this so wonderful animal protection conference meeting. Yes, today my topic is research on public interest litigation of wildlife protection by prosecutors in China. I choose this case first because that's about wild animal protection. Second, because most litigations, especially the animal protection litigations, just raised by prosecutors in China. I once worked in China's our own base district prosecutors, procuratorate for 2 years. So here, just give you the pictures. The left one is procuratorate. That's an independent judicial organ in China, not as the United States. It's independent one. So this building just all the prosecutors just stay inside this building. And the right one is our Minhang district courtroom. So here is one courtroom, the biggest one. I also worked in Shanghai Environmental Protection Bureau for 1 year, still full-time. So here is our administrative organ, just to give you the pictures. So today my contents would be 3 sections. The first section is overview of China's wildlife protection law and the legal system of the ordinary animal protection, not too much. So here I just talked the wildlife protection law and other animal protection law or regulations at the same time. Second one, I focus on the public interest litigation for wildlife protection by China's prosecutors or procuratorate. Section 3 is the future challenge and prospects about the above. So in China, the high risk level of China's wildlife protection law of the PRC, People's Republic of China, is only one. In 1988 by our standing committee of the National People's Congress. So this one I just mentioned is a high risk or even the only one. It's amended in 2004 and 2009. Amended in China, the term means it's not changed greatly. In July 2016, this time, the wildlife protection law of the PRC just revised greatly. So now we call it the revised. And in 2015, another amended again. Then a landmark is 2020 at the beginning of the pandemic. So our new wildlife protection law of PRC just in the process of revision. So this time is still a revision, but this time is really long and a little bit unclear. So at present, it's still in the process of revision and not come out the new one. But why I said at the beginning of 2020 is a landmark, because our People's Congress, they issued a decision, Congress, their decision have the very effective legal results or effects. They named comprehensively prohibit the illegal trade of wild animals, break the bad habit of excessive consumption of wild animals, and effectively secure the life and the health of the people. It's issued at the on February 24th, 2020. So at the beginning of 2020, at the beginning of this pandemic. So this decision, the first part, the illegal trade of wild animals. So most you can find the clue in the environmental in the wildlife protection law of PRC. I just mentioned that, but the new cruel is break the bad habit of excessive consumption of wild animals. So here you can see the decision, this decision from the Congress has really made a new start of the animal protection, especially the wild animal protection. So here I concluded, not only me, some scholars of environment protection or animal protection, they concluded the 3 stages. The first evolution from the disordered utilization of animal wild animal to protection of the state-owned animal natural resources from 1988 to 2016. So from this time, we regulated that all the animals belongs to the state-owned resources, natural resources. So you cannot take the animals as your own property. You must think about that belongs to the state-owned natural resources, and some name list just regulated in our wild animal protection law that some you cannot damage or hunt. The second evaluation is regulated utilization for commercial purpose. The revised wild protection law, I just mentioned the first big revised in 2016. At first, the original said reasonable utilization and they changed that to regulated utilization and deleted some old words like active, domestication, and breeding. Maybe some Western friends a little bit confused what's the meaning of that. But in China, we have a longer history, maybe several thousand years history. So the relationship between the wild animal and the Chinese people a little bit closer sometimes. And in a long history, we just looked at the wild animal as some natural resources, and we can maybe use its fur, its meat, or they are born as some traditional Chinese drug or something. So medicine. So something we can at first, we think active domestication and breeding may be a very good positive thing, but now we think, no, maybe not. So in 2016, after the NGOs and some experts and some, protectionism and all their efforts, so the active utilization became regulated utilization, but that's still maybe not so enough. But the third stepping into a deepening reform with fasting as an entry point. So that's from 2020 until now. So the reform, the fasting is not the end. I think that's just the beginning. We will still think about the animal relationship with the people, human being. Here, I really want to mention some other animals, because in China, we only regulate greatly about the wild animal and the people or wild animal protection, but we still have farm animals, zoo animals, lab animals, and companion animals, just as Professor Qian just mentioned, and have some discussion with our audiences. So for farm animals, we just have some international standards or European Union standards. So we follow the some, especially for business. So the technical standards for individual or some types of the animals, but of course, not very high level, just the standard. And zoo animals, not very clear or strict management measures yet, and lab animals still as just followed some international standards and rules, because for the WTO, for some international service trading, you must have some uniform standards with other countries. The first one, company animals, we have some part of the ban on slaughter, but just now Professor Qian mentioned some Chinese reality and some conflicts. So anyway, so here I focus on the China's wider animal litigations because we have this kind of litigation. We should have more regulations, legislations for the ordinary or different types of animal protection. But now I only can study the wildlife protection by the prosecutors. So, but the good thing is from the beginning of 2020, that decision from the People's Congress, that's the first landmark. The second is during the past 2 years, we hosted the Biodiversity Convention's COP conference. COP 16, or that COP conference of diversity. So our Chinese judicial organs, they issued a series of cases, especially public interest litigations, stand by the national's interest or even the ecologicals, their interests. So a lot of guiding cases. For example, in 2020, from January to September, the criminal cases or the people who are persecuted by the criminal cases or the prosecutors just increased 66%. And the next year, 2021, I did not have the exact number, but still many cases increased much than before because I just mentioned it has some international influence or some international convention. So here I just gave you a list. Many these kind of a series of cases just issue. For example, the Spring People's Procuratorate released 6 typical cases of public interest litigation for wild protection, and the third one because, for example, the Supreme Court. Oh no, that's the Supreme Court. The third one is. Oh yeah, still Supreme Procuratorate. So yes, most from the prosecutors, but we still have some from the courts, and for many different aims, maybe for biodiversity protection, maybe just protect the animals, or they just want to protect the Yellow River Basin or Yangtze River Basin, and maybe some local Fujian province or Guizhou province, they issued some typical cases related to COVID-19. Of course, that's still have the relationship with animal protection, wild animal protection. So I collected hundreds of typical cases. So here I just give you some those photos, how they deal with this kind of cases and the courtroom, the decision making, and that's some litigations raised by the prosecutors. So here I just want to conclude some characters or some difficulties or challenges in China for wild animal protection. For example, the wild animal is a term in China, but when you really define what is wild animals, mostly maybe you can face some difficulties. The wild animals still can be divided into artificial population and wild population. For artificial one, maybe it can still be divided into artificially bred animals from the natural prevalence and, or the captive bred animals from natural reproduction. And the second part, the wild population, may be the release of the artificial bred animals into wild, or the release of the artificial bred in, oh, sorry, that's not the same. It's a typo. So different type of the last one is the typical wild animals from the nature and lived in nature. So yeah, so here in China, when we faced the 4 types of wild animals, we always confused. I talked with the industry department bureau many times, and the first time they asked me to explain is what is the meaning of wild animals, because in China the relationship between the wild animal and human being a little bit too close. So the first conclusion I conclude that from 2020 to now, because the public interest litigation is a kind of civil litigation raised by prosecutors, but most cost or just they find those cases clues from the criminal cases, because in China we have many criminal cases by prosecutors, and also the public interest litigation function still belongs to the prosecutors, so they can gather the criminal cases and the civil cases for public interest litigation gathered together. The advantage of this is you can combine the resources of the different departments inside the prosecutors gathered together. So the criminal department, they deal with this kind of case at first, then the second part of the public interest department can raise these cases again, or even gather together. But the disadvantage is in China, we have 2 different plaintiffs. One is the animal protection NGO, environmental NGOs. Another is prosecutors. And the NGOs, they have only 1 month the right for early action if they want to sue the public interest litigation. But, the criminal case is just made by the prosecutors. So if you want to cut in and make this kind of public interest litigation for those wild animals, it's too different. It's too difficult. So here, I just want to point that the civil public interest litigation for NGOs to protect the wild animals is maybe more difficult in China. You must find some new ideas and make some creative litigation. Like Friend of Nature, they sue the green peacock. They sue the green peacock and make a great success, and it's very famous in China, even sometimes in the international world, because they sue their habitat protection instead of only protect this type of animals. Okay, that's the second characters is our prosecutors. This kind of public interest litigation is still very narrow. Mainly focus on the illegal cases of wild animal hunting or killing, this kind of case. But in China now, because for example, the tools, the time of committing the crimes, they are all very difficult, and the training routes or chains of animals all involved different sections, different process, and the whole process of the black industry chain of the products. So all those aspects who can get the economic interests. So maybe we just focus on who hunt the wild animals, but no others. So after 2020, this kind of cases just changed a little bit, because maybe sometimes we sue, we sue more the whole process of the black industry chain, but that's really difficult. We know that it's easier to just find the hunters than the whole chains, but it's really increase the field of the illegal crimes. The third one is for the ecosystem damage. Before 2020, we seldom have this kind of cases, but now we have more cases focused on the ecosystem damage. Then we pointed out that's influenced the wild animal protection. So finally, the compensation of those cases just can maybe can pursue from the prosecutors to the ecosystem damage. The last one, maybe we have many more characters, but very typical one is this kind of case is still very difficult for scientific calculation, decision knowledge. So we have a lot of experts, animal experts, their opinion. So now I introduced some of these wild animal cases, especially public interest cases, mostly from the public interest cases. But from the IUCN's reports recently, we know that the relationship between the wild animal and the people's relationship may be not so dangerous. Most dangerous relationship is still between the ordinary animals and the people. So they said many problem or disease caused by only more than 1% by the wild animal, but 99% by the ordinary animal. So in China, we must focus more relationship between the ordinary animal, their relationship, especially the Chinese traditional knowledge or traditional just their habits, their tradition. That's we need to reflect it. We need to reflect that. We need to think more about that. We cannot see, okay, we did that for 4,000 years, so that's no problem. Maybe not. So we hope we can have a comprehensive environmental protection law and animal welfare legislation follow of a Chinese animal, wild animal protection law. Thank you so much.
Thanks a lot, Professor Zhao, for actually in your final remarks points a way for the future legislation and enforcement of China's wildlife and animal welfare law. Thank you for your great perspective, not just from a scholar, but also from a petitioner's the prosecutor's perspective. And you also mentioned the innovative practice from the Chinese NGOs. So great. So now we want to turn to Professor Cao, that she can share the Australia's animal law. So let me share the screen, and Professor Cao, the floor is yours.
Thank you. Thank you very much. Thank you very much. First of all, I'd like to thank the organizers for inviting me to make a presentation in this very important forum, and I'm very honored to be here. And I'm going to talk very briefly about animal law in Australia, in particular wildlife law in Australia. To begin with, I think it is appropriate and fitting that I start by quoting the words of a great American who is also very much admired and very well known in China, although these words I'm going to quote may not be very well known. In the zoological gardens of Adelaide, I saw the only laughing jackass, the kookaburra, the 小翠鸟, that ever showed any disposition to be courteous to me. This one opened his head wide and laughed like a demon, or like a maniac who was consumed with humorous scorn over a cheap and degraded pun. It was a very human laugh. If he had been out of sight, I could have believed that laughter came from a man. It is an odd-looking bird with a head and a beak that are much too large for its body. In time, man will exterminate the rest of the wild creatures of Australia. But this one will probably survive, for man is his friend and lets him alone. Man always has a good reason for his charities towards wild things, human or animal, when he has any. In this case, the bird is spared because he kills snakes. If the bird will take my advice, he will not kill all of them. In that garden, I also saw the wild Australian dog, the dingo. He was a beautiful creature, shapely, graceful, a little wolfish in some of his aspects, but with a most friendly eye and social disposition. The dingo is not an importation. He was present in great force when the whites first came to the continent. It may be that he is the oldest dog in the universe. His origin, his descent, the place where his ancestors first appeared, are as unknown and as untraceable as are the camels. He is the most precious dog in the world, for he does not bark. But in the evil hour, he got to raiding the sheep runs to appease his hunger, and that sealed his doom. He is hunted. Now, just as if he was a wolf, he has been sentenced to extermination, and the sentence will be carried out. And this was written by Mark Twain in 1897. And I quote Mark Twain's beautiful, sad, and also profound words, because for our purpose here today, they have great relevance when we talk about wildlife protection, about animal-human relations. Even though those words were written over 100 years ago, a major issue described and identified by Mark Twain is very much with us in today's Australia, and in fact, in all the modern legal protection laws and regulations of wildlife and animal in general, in all human societies. That is, animals are legally protected and harmed depending on their usefulness or perceived usefulness to humans. The laws to harm or exterminate animals and the laws to protect animals have been written and implemented standing side by side. And this was true in the past, as Mark Twain described. It is also true today, and unfortunately, in the foreseeable future. It is a contradiction that is not unique to Australia, but universal to all human societies. Animal law, in a way, is an example of such a paradox, such a contradiction. That is, the law protects animal from human abuse and at the same time legalizes human abuse or violence against animals. And this is done to the extent to which animals can be used to serve human interest and for human benefits. And in many instances, in most cases, even the smallest and the most insignificant human interest or benefits prevail over animal interest. I'll say a little bit more about this later. And the next slide, please. Now, I'll say very briefly, outline the animal law situation or wildlife protection law in Australia. As you know, Australia is a common law country, and under the common law, we have generally we have two basic broad categories of animals. One is the domestic animal, the other category is wild animal. And in Australia, we also have animal welfare legislation, and the law also divide animals into different categories according to the domestic setting or treatment these animals are used or perceived to have their purposes. And for instance, for instance, we have the laws for companion animal, and we also have laws and a system of regulation for animal farms for food, and we have other laws and regulations for animals used for sports, for recreation, and for other purposes, and other working animals. And also we have laws and regulations for animals used for research and teaching and experimentation. And then we also have the wild animal protection law. But why do we have these different categories of laws? And again, this is not just the unique situation in Australia. This is actually in most or all actually jurisdictions around the world. That's how animals are classified, and the laws are enacted and implemented, treating different animals differently. And for instance, the practices or some behaviors and practices and acts done to animals in one category may be regarded as acts of cruelty, may be criminal offenses in other categories. But the law classify animals this way and treat animals differently according to the uses that humans have for these animals. Because animals and nature do not have such classifications. And these categories and the categories of laws are human artificial constructs. And they are there because of the purpose of use. Human invented for animals entirely for human created purposes, serving entirely human interest for human benefits. And that again is what Mark Twain actually referred to earlier. And the next slide, please. And we also have separately, we have animal welfare legislation in Australia. And Australia is a federal system. So we don't have a national animal welfare law for Australia. Instead, we have different animal welfare acts in different jurisdictions within Australia, in the different states and the territories. For instance, we have listed there, for instance, in New South Wales, in Queensland, and in other parts of Australia, we have individual animal welfare legislation governing the animal regulation in different jurisdictions. And apart from that, we also have different animal welfare codes of conducts and standards and guidelines. I won't go into detail there. Next slide, please. And then regarding wildlife protection. And for this, we do have a federal national law called Environmental Protection and Biodiversity Conservation Act, and this applies to the whole of Australia. And it regulates the international movement of wildlife and wildlife products to and from Australia. And also we have other federal laws, for instance, the Custom Act and the Quarantine Act and other laws and regulations governing the import and exports of animals and animal products. Next slide, please. Again, this area actually is very complex. It's a very broad and complex area, but I won't go into detail there. And here, and there are various, code, for instance, codes of conduct for killing animals. For instance, there's one called Humane Destruction of Kangaroos, and this has been implemented in different jurisdictions in Australia, simply because humans think that we have too many kangaroos, or for whatever reason, so we need to wipe them out. We need to kill them in large numbers. So this, again, is an example of the issues Mark Twain identified earlier, that when animals are deemed to interfere with human interests, when deemed to be redundant or hurting human interest, then animals will be harmed, will be exterminated. And I'm sure that all of you can think of examples in your own culture, in your own society, in your own jurisdiction, in your own laws of such practice. Actually, such practice is universal, unfortunately. Just lastly, as I wrote and said many times before, humans are actually the leading cause of pains and suffering and the destruction and death for other animals, and including wildlife extinction. And animals do not need humans in order to live or survive, and they lived independently from humans over millions, hundreds of millions of years before humans evolved and live on this planet. And so perhaps humans should maybe should leave the animal alone instead of interfering in their life, instead of treating animals as tools and instruments for human purposes. And next slide, please. Yeah, because this is very short of time and I can't go into details. And the last slide, please. The last one. No, the previous one. Yes, if you're interested in animal law in Australia, I have actually written a book. And if you're interested, you can have a look at this. And this is the second edition, the first edition of Australia and New Zealand. The second one is Animal in Australia. And a third edition is coming out next year. But for some of you who are interested in animal law and welfare from an international perspective, this is the book I edited. The next slide, please. In particular, I would like to highlight some of the papers in this collection. some of the papers about animal law and including wildlife protection in countries, in non-Western countries, for instance, in South Africa, in Israel, in Brazil. And if you're interested, you can have a look. And also an article by Professor David Faber on the International Treaty for Animal Welfare that Professor Schaffner mentioned earlier. And also, we also have a article by Professor Schaffner on the situation in the United States in wildlife protection. Next slide, please. And if you're interested in animal law in China, and I also have a book on this topic in English, the animal law and society, but mostly talking about the legal situation and the regulation of animals in China. And if you read Chinese, I also have a book. I'm sorry about the self-promotion. The book is written quite some time ago, and it's about animal law in the West. Even though it's a little bit old, but the basic, the law and basic principles, and I think is still valid and still applicable if you're interested in this. So thank you very much for being here. And again, I would like to thank the organizer for inviting me to talk to you. Thank you.
Thanks a lot, Professor Zhao. If we are in a meeting room where, like the Chinese tradition, will clap our hands, and thank you for your great presentation and provide us such a rich resources to follow up. We're actually getting a lot of requests from WeChat that they want to join, but we have this participant limits. But we definitely will share this resources with them. And in your presentation, you will not only just provide your perspective on the animal law in Australia, you actually already give a comparative study, and you found the same trend or the same foundational concept or legal principles that regulate the current animal law. Really appreciate your insights.
Thank you.
So without further delay, I would like to give the floor to our two speakers that they can give our perspective on the European Union's law on animal welfare, wildlife protection. Please, Professor Alice DeConsato and your students, Mila Arapashiva. The floor is yours. Thank you so much.
So I'm just gonna, I need to share my screen, and I have a message saying that, yes, okay, great. So I think you should be able to see my slides. Please let me know if that's not the case.
I can see it.
Okay,
Great.
So good morning, good afternoon, and good evening, everyone. And thank you to the organizers of this conference for inviting us to speak today about EU wildlife law. So to provide a bit of a comparative background, Europe, unlike China and the US, is not what's called a mega diverse area in terms of its wildlife. Indigenous European wildlife has been decimated over the centuries as the result of human settlement, wars, urban sprawl, and the introduction of species from other continents. Some initially native species have been reintroduced, such as wolves and bears, but this reintroduction has occurred only very recently and with considerable resistance from human communities. As a result, there are very few large predators in Europe, and contacts between wild animals and human populations are very limited compared to the US and China. So you really have to understand that when you're in Europe, especially continental Europe, you won't see any raccoons, any possums, no monkeys, nor big cats, nor crocodiles. We don't really have large insects such as cockroaches or big spiders. And European wild birds are also very small compared to American wild turkeys or Chinese pheasants. And also, even squirrels are very rare in continental Europe. So for that reason, when a European catches sight of any sort of liminal animal in the Americas or in Asia, it's quite likely that they may become very excited. And here I can speak from experience by sharing that my favorite wildlife moment when I lived in the US was seeing wild turkeys casually strolling the sidewalks of Cambridge, Massachusetts, which is something you will never see in Europe. Despite the relative scarcity of wildlife in Europe, these creatures face the same types of challenges for survival that other wild animals do in other parts of the world. So for instance, foxes, seals, whales, polar bears, of course, pollinators such as bees and butterflies are amongst the most endangered animals in Europe. To counter the trend of wildlife decline in Europe, EU law protects wild animals through the species conservation and habitat protection policies. A central point in discussing the legislation pertaining to, well, pretty much everything in EU law, but especially animal protection, is that of competence, which relates to the same issue as preemption in the US, and is pretty much about determining which level of government is going to regulate certain areas of laws and policies. One important element to keep in mind is that the EU is a mix between a free trade area, an international organization, and a federal government, which means that the debates and the answers around EU competence are not set and can evolve quite rapidly over time. So at this point, and without getting into the technical details of debates around EU competence, all you have to know is that the EU preempts any national rules. So we say that the EU has an exclusive competence when it comes to trade with non-EU countries, competition rules on the EU market, so the equivalent of interstate commerce, customs and border protections, and the conservation of biological resources under the common fisheries policy. However, the EU has a shared competence, meaning that the member states have a large latitude when interpreting and implementing EU law in the areas of environmental policy, rules other than competition rules related to interstate commerce, transport, and public health. So beyond the issue of competence, environmental protection benefits from a particular legal status in the EU constitutional treaties, as the preservation, protection, and improvement of the quality of the environment are constitutional objectives under EU law. And additionally, the Charter of Fundamental Rights of the EU provides that a high level of environmental protection must be integrated into the policies of the Union.
Also, Article 13 of the EU Constitutional Treaty recognizes animal sanctions and requires that the Union and member states pay full regard to the welfare requirements of animals in formulating and implementing the Union's policies. EU law pertaining to the protection of wild animals could be situated in the intersection between environmental law and animal welfare legislation, which could spark a much needed dialogue between environmental ethics, which traditionally view animals as members of a species, and animal ethics, which views animals as individuals with their own self-interests. So during this presentation, we will discuss the protection of wild animals, especially endangered species under EU environmental law, and also the significant shortcomings of EU law in addressing the protection of wild animals in captivity. So EU conservation legislation is quite comprehensive as it approaches wild animals protection by either affording protection to habitats through the Habitats Directive or to species through the Birds Directive. And a directive is just a type of an EU legislative act. And these two directives and directives in general set minimum standards, but member states can later on adopt stricter rules in their national legislation. The Habitats Directive in particular aims to ensure the conservation of a wide range of rare, threatened, or endemic animal and plant species, covering both vertebrate and invertebrate animals. And its main instrument in doing so is the creation of conservation sites, forming a network throughout the EU's territory called Natura 2000. And Natura 2000 sites must be protected from external, potentially damaging influences in order to maintain and, if possible, restore the natural habitat types and the species habitats. The Habitats Directive, therefore, establishes 3 groups of species depending on their conservation status. Annex 2 lists species whose conservation requires the designation of Natura 2000 sites. Annex 4 lists species in need of strict protection, and so their deliberate capture, killing, disturbance, destruction, and/or taking of their eggs, and the deterioration in general of their breeding and resting sites is prohibited. And finally, Annex 5 lists species whose taking in the wild and exploitation is not regulated at EU level, meaning it's up to member states to regulate it themselves. But an important limitation of the Habitats Directive is that it leaves significant latitude to member states in managing the designated protected sites. It even allows them to improve industrial projects on Natura 2000 protected sites and merely requires that they run an environmental impact assessment beforehand. If that assessment is negative, it allows the project to carry on, quote, in the absence of alternative solutions for reasons of overriding public interest, including those of social or even economic nature. And as a result of such a lenient approach to conservation, 40% of the land of Natura 2000 sites are today farmlands. And if you look closely at these 2 maps, you can see that areas with high livestock densities overlap with many Natura 2000 sites. The Birds Directive covers the protection, management, and control of all species of wild birds native to Europe, their eggs, nests, and habitats. And 2 different measures apply to all wild birds native to Europe. First off, there's the designation and management of protected areas. And secondly, there is the prohibition on the use of non-selective hunting methods. And the Birds Directive categorizes wild bird species under several categories. Annex 1 has particularly threatened species subject to special conservation measures. Annex 2 has species which can be hunted in limited hunting periods. And finally, Annex 3 lists species for which, with certain restrictions, member states can allow some hunting and capturing activities. However, the scope of the protection measures in the directive is limited by exemptions that member states are allowed to carve out in their national legislation, such as economic and recreational requirements, and also cultural exemptions. The Birds Directive prohibits non-selective hunting methods, that is, methods that indiscriminately kill birds of all species, including protected ones. And the glue trap is one such method. It's an adhesive substance spread on a branch on which a bird lands and is then caught. And the glue causes immense suffering to the birds by ruining their plumage and rendering them unable to fly. However, the French legislature allowed its use in certain regions of France on the grounds that glue traps are a traditional hunting method in these regions. But in a 2021 ruling, the European Court of Justice ruled against the French government and against this practice and in support of animal conservation and welfare. A particularly relevant fact in this ruling is that in reaching its conclusion, the court relied on Article 13 of the EU Constitutional Treaty, which, as a reminder, requires member states to take into account the welfare of animals when implementing the EU's policies. And the mentioning of Article 13 in this ruling is interesting because it's rarely been mentioned in the context of wild animals, and also because environmental policy is not one of the policies listed under Article 13, even if the EU legislature can voluntarily take into account the welfare of animals in implementing this policy. This 2020 ruling concerns the capture and relocation without prior authorization of a wolf present in a village located between two protected sites under the Habitats Directive in Romania. The wolf is a protected species under the Habitats Directive, and the deliberate capture or killing of members of its species is therefore prohibited. Here, the court ruled that the wolf's natural behavior leads him to occupy vast stretches of territory, which is why it was outside the protected site. And reasoning from the perspective of the wolf, the court concluded that the protection under the Habitats Directive continues to protect animals even when they stray out of protected sites and into human settlements. And this ruling is relevant from an ethical perspective as well, because the protection becomes attached to the individual animal as opposed to being strictly linked to a given geographical territory. And therefore, the legal protection regime moves with the individual animal. And in order to restrict and discourage trade with animal products derived from cruel hunting methods, the EU has attempted, with more or less success, to implement trade bans on such goods. First off, in 1991, the use of leg hold traps was prohibited by means of the leg hold traps regulation, and the import of furs obtained by means of such traps was also banned. However, subsequently, the regulation was left unenforced by the EU executive. Similarly, the EU implemented a ban on the trade of products originating from the hunting of seals on the grounds that the hunting methods used to catch them were contrary to public morals.
Thank you. So Mila discussed the regulation of animals living in the wild in the EU. And in this section of the presentation, I will discuss the regulation of the treatment of wild animals kept in captivity, specifically exotic animals. And by that, I mean animals that are not native to the EU and who are primarily kept in captivity for entertainment purposes. So I won't go over the CITES since Delcy detailed that convention in details. The EU member states are all signatories of CITES, and the EU has exclusive competence in trade with non-EU countries, and so the EU is tasked with implementing CITES at the EU borders. As a result, the EU legislature has adopted a series of regulations that ensure the implementation of CITES. And the main regulation is Regulation 338/97, which also resorts to a system of annexes from A to D. and each annex assigns a protection regime to the listed species based on their conservation status. Species listed under Annex A benefit from the highest level of protection. For those animals pertaining to those species, the commercial exploitation, including the display to the public for commercial purposes, is prohibited. So the implementation of CITES within the EU can be stricter, can lead to stricter rules than the rules in the CITES. For instance, the annexes in the EU regulation protects animals that are not necessarily covered under CITES. Import conditions for species in annexes A and B are also stricter than under CITES, in that the issuance of permits is always subject to the opinion of a scientific committee. However, member states are able to enter reservations from the CITES, and Regulation 338 further provides an exemption from the trade of species listed under Annex A on the basis of education, research, or breeding purposes. So even though EU law limits the trade of exotic species to the extent that it implements CITES, EU law still carves out a significant exemption which enables the keeping of exotic animals in captivity and for commercial purposes. So when it comes to regulating the treatment of animals in captivity, the EU legislature is competent to regulate the living conditions of animals in zoos, to the extent that zoos are considered in EU law as well to carry out a conservation mission. However, when it comes to animals in circuses and animals who are privately owned, the EU legislature has adopted a very conservative approach to its ability to regulate the treatment of those animals by considering that it doesn't have competence to enact legislation because the number of animals in these situations is too small to affect the conservation status of the species concerned. So let's first turn to the EU legislation pertaining to the regulation of zoos. It covers all permanent establishments where animals of wide species are kept for exhibition to the public for 7 or more days per year, with the exception of circuses, and member states are further allowed to exempt certain establishments from the zoos directive on the basis that they would have too small number of animals. I'm so sorry, there's my very old cat who's requiring my attention, but I'll just keep going. Even though the directive requires member states to enact legislation to ensure that the biological and conservation requirements of animals are satisfied, the directive only uses extremely vague language and requires no measurable standards regarding the enrichment materials that should be provided to animals in zoos or breeding standards. As a result, living conditions of animals in European zoos are mostly regulated at national level, with many member states providing very lax standards of care for animals in zoos. Breeding programs in zoos also lead to significant number of killing of healthy animals who can be reintroduced in the wild, with the European Association of Zoos and Aquaria estimating that between 3,000 and 5,000 animals are euthanized every year. So again, those are perfectly healthy animals who are simply killed because the zoos have too many animals. In 2016, and despite this many euthanasia, in 2016, the European Commission found that the directive was fit for conservation purposes and so did not need to be amended. So the treatment of animals in circuses in the EU is regulated at national level only, as circuses, as we saw earlier, are explicitly excluded from the scope of the zoos directive. And the EU legislature has persistently refused to enact legislation on this specific matter. Yet it is our opinion that the EU legislature should be able to regulate the treatment of wild animals in circuses. So first, to the extent that many wild animals in circuses are classified and categorized as endangered species, but also based on the fact that circuses are an extremely lucrative interstate commercial activity and one that poses significant risk to public health. So just to give you a number, since 1995, almost 500 accidents involving animals in circuses were recorded in the EU, causing 13 deaths in humans and probably also in animals. So because the regulation of circuses is entirely left to the discretion of member states, the EU counts many different rules at national level. It is true that the majority of EU countries prohibit the use of wild animals in traveling circuses. So I really insist on the fact that those are prohibitions only concerning wild animals, not animals as a whole, and in traveling circuses only, not circuses that don't travel. Only 4 EU countries have prohibited the use of all animals in circuses. Those countries are Cyprus, Greece, Romania, and Malta. And 2 countries, Italy and Germany, allowed the use of wild animals in traveling circuses. So hopefully this practice is slowly ending, as France actually just prohibited the use of wild animals in traveling circuses last year. So like animals kept in circuses, the EU doesn't regulate the treatment of wild animals who are privately owned as pets. Here again, the EU could use many different competences to reduce the suffering of endangered species, but it doesn't. And interestingly, the EU legislature argues that the number of privately owned animals of endangered species is too small to affect their conservation status. But at the same time, the EU doesn't even monitor nor collect data on the number of exotic animals kept as pets, and so is in fact unable to tell whether the conservation status of the species remains unaffected by the private ownership of wild animals. So just like for circuses, member states have disparate legislation regarding the private ownership, this time specifically of tigers, which I thought was a relevant example, with some member states prohibiting the practice, others allowing it, but sadly, unlike for circuses, the practice of owning tigers as pets is still allowed in many EU jurisdictions, and there haven't been real change in the past few years in terms of legislation for that particular practice. Thank you so much for your attention, and we both look very much forward to any questions or comments you might have. Thank you.
Yes, thank you, Alice and Mila. It's a great presentation. Thanks a lot. We know we also a little bit run out of time, and I also saw a lot of discussion happening in our chat room. So I will just select some of the, I think, the most interesting and key questions, and then for the speakers to respond. I hope this is okay. So I think the first question is for Professor Zhao. The questions is, I can say in Chinese and you can listen to the English translation. 有2个相关的问题，一个是说，如果取消了野保法的25条里的野生动物子代的条文，是否会更容易起诉涉及利用方面的违法行为？就是不仅是主要针对这个非法捕猎的。还有另外一个问题，也就是说，通过这样的野生动物的公益诉讼的话，是否能够对动物福利也会有所促进？
Okay. Let me answer that in Chinese or English. Let's try English at first. So I think the Article 25 for the artificial breeding, I think it's not very, I think that's a reasonable article. It's not the obstacle for those wildlife protection, because they said you need to have the approval by the supervision organs, and you must have this kind of certificate, then you can do that. Why they have this article? For example, for panda in China, many endangered species, maybe you want to protect it not only can by the natural force, you must rely on some artificial methods. So I think this article is meaning for that. but that not means we breeding a lot of wildlife for meat or for fur or for, you know, those byproducts. That's just for biodiversity or for some, you know, saving the endangered species, just for this aim. Another, let me see, your another question is,
就是检察院提起的这个公益诉讼是否会就是对保护动物福利有所促进？
这个我用汉语来回答，因为我们觉得我们这边的这个汉语的听众也比较多。是这样子的，就是实际上我们国家现在的公益诉讼，检察机关的公益诉讼几乎全部都是围绕着野生动物的保护，而且不是全过程的保护，只是最多的，刚才我讲的就是你在猎杀呀、非法捕猎呀这方面是比较严格的，而且也比较容易固定证据，比较容易进行诉讼的。但是它的全过程还有整个的，就是所有的一般的动物的福利问题都不在保护之列，因为我们国家没有对，就是我今天提到的农场动物啊，还有那个这个实验动物啊、伴侣动物啊，还有其他的，包括动物园动物，有很多的一个保护的措施和立法。所以说，我们的检察机关不能够对没有立法的东西进行保护，权利保护。所以说，从这个意义上来讲，我们检察机关进行公益诉讼，或者我们的 NGO 进行公益诉讼，几乎只能够围绕着野生动物，而且是一定范围内的野生动物，或者是一定环节的野生动物的捕猎来进行的。当然，这个主要是因为有时候有这个立法上的限制。还有一些实际上的操作上的实务上的困难，所以从这个意义上来讲，我今天来谈野生动物的公益诉讼本身就很无奈，因为我们的普通的动物的诉讼几乎无法，就是动物福利几乎无法可依。
好的，谢谢张老师。因为确实时间有限哈，那我们就迅速再问2个问题。应该刚刚看到一个新问题是问最后2位发言人的。就是想请教一下，欧盟是怎么样协调这个在有限的空间里面，如果就是人使用的空间跟野生动物使用的空间产生冲突的话，法律有没有解决的方法？
你说这个是不是？这个办法。
Yes, so it's kind of a question I want to ask to the EU. I mean, it's to the EU legislature. So far, the EU legislature has really taken the approach of protecting the animals, the species that are endangered to the point of being extinct. And you can see that most of the time, actually, human interests actually take over animals' interests. So Mila was explaining the limitation of the Habitats Directive, for instance, when it comes to approving industrial projects on protected sites. You can see a very broad exemption when it comes to, well, even if the environmental impact assessment is negative, if you have economic interest that can justify this project, then, you know, so be it. The interest of wild animals is neglected in that perspective. So yeah, it's been very difficult. I know when it comes to the reintroduction of certain wild species, so I briefly mentioned that for bears and wolves. Again, the interest of usually farmers comes into conflict with the interest of those animals, and sadly, most of the time, the human interests take over the interest of animals. So yeah, it's been very difficult in practice.
Thanks a lot, Alice, for your question, for your responses. I think the final question will direct to Professor Zhao. Actually, the question about like who determine an animal is a pest. Is there a wildlife management program in Australia that actually authorize specific like culling programs based on science and conservation principle rather than like just more arbitrary to determine the animal is a pest?
Yes, they do. They do have programs to determine that, and based on very effective. And also they also have the corresponding laws and regulation for that purpose. For instance, as I mentioned, they have what they call humane destructions of animals, and but still they're killing them, and it's not done randomly, obviously, and it is still quite controversial in Australia also, to do this. But the main problem I see it is that humans simply kill large number of animals. Simply they don't want them. And also EU, the situation in EU also, just now it was mentioned, and large numbers of animals just are killed simply because they think it's too many of them, and with no other reason. So this is a problem in all societies, that humans just arbitrarily, it is, even though it's based on science or based on whatever reason, but it is human, arbitrary decision to kill large number of animals because human society say we don't want them. But that is wrong. And so that is the, I think that's the mentality, people's attitude, people's mentality. We as society as a whole need to address and need to consider. It is difficult. There are no simple answers to this, but as a society, as human society, we need to address these issues. We cannot simply say because we think they are a burden to society, we think to humans, and they interfere with human lives or whatever. And sometimes just with no reason at all, people just, people can, just kill large number of animals. And so that is an issue that human societies as a whole, not just Australia or not EU or any particular society, but human as a whole, human as species, need to address. Thank you.
Professor Zhao, your final comments. I think it's really important because you really call all of us, including all the participants and speakers, really to think deeply. We consider what our concept and towards the animals and how we structure our relationship with the animals. Thank you so much, and thank you all the speakers. Really appreciate your taking your time to participate in this event, and also thanks for all the participants to raise all this wonderful question. And I saw many discussions still going on in the chat room. So we definitely, I also want to thank Professor Delcianna and Professor Zhao Huiyu. They are truly the leaders to organize this program, to invite such wonderful panelists. And I just want to say yes. Thank you, Alice. This motion, because like in Chinese, we just clap our hands. Yeah. So Substitute, do you want to say some final words, and then we might give some time for our Chinese participants go to bed and our speakers to enjoy the weekend.
Yes. I think this is actually a great discussion, and kind of brings up, I kind of like the concept of, humans and environment and animal protection. It's all up, the discussion had been about balancing, but I can't really like what Professor Schaffner had set up is the one health. It's like helping one species will actually help us too. So I think we need to think about this in a way of that we cannot survive without a healthy environment and healthy different species in the animal species. So Thank you very much. I hope that we can continue this discussion. And this is, it goes to show we have more than 100 people who want to join in this workshop, even in the middle of the night. So I hope that we can continue to do this and have more discussions around these type of important issues. Thank you very much. Oh, one more thing. I was wondering, can we take I know we can't take a snapshot of everybody, but if people are willing to turn on their cameras, we can at least take one, someone who can actually able to do that. I don't know how to do that. So maybe we can do like several pages because there are at least 4 pages, 4 screens. That'll be great.
Yeah.
Can take the screenshots.
Okay.
Yeah.
I don't know how to do it. Great. So if you'd like, you can turn on your camera. Thanks.
Yeah. So there.
Good to see people's faces. Great.
I'm going to give it just another minute because people are gradually joining us.
Okay.
And I really appreciate, I know there are so many other participants that really wants to join, that we have a limit of 100 participants, especially for the Chinese students who are participants. If you really want to revisit the recording of this seminar, please add the WeChat account of Vermont Law School. That's VLS_admiss, ADMISS. I know because when we're posting on the Vermont Law School website, it's through YouTube, so that might cause access issue. So, 福蒙特法学院的微信号是 VLS， 然后下划线 ADMISS， 我发在这个微信里，这个我聊天框里面。那如果有其他的同学还想通过微信，我会那个分享一个云链接，让大家来再看回放。很抱歉，今天的这个人数是100人的上限。之前我没有这个意识到有这么多的同学，也没有意识到这个上限，很抱歉。所以大家可以加福蒙特法学院的这个微信号的这个公共微信号。所以我把这个再发到那个群里面。就是这个。或者是如果大家后续如果有问题的话，也可以给我发邮件。
Thank you.
Yeah, just in case, I was saying, just in case.
Please,
Yeah.
James.
Translation.
Thank you, all the participants.
Thank you. All right. Delcy, you doing the snapshot?
Yes, I got some, and I'll send them to Claire.
Yes, great. Thank you. Thank you. Have a good afternoon.
Thank you so much. Bye.
Thank you, everybody.
Thank you, 大家。
谢谢大家。
Thank you. Really good to see everyone. Bye-bye.
Bye.
Bye, everyone.
Thank you. Bye.